Good afternoon, everyone. Welcome to our program today entitled Managing Donated Funds, Donor Intent, Restricted Funds, and Gift Acceptance Policies. Today's program is a joint presentation by Venable and the BDO accounting firm. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice at the Venable Law Firm, and as many of you know, this is part of the monthly series that we do of seminars and webinars on nonprofit legal topics. Today's topic is clearly a very popular one because I believe we have broken even our own attendance numbers and registration numbers with a very packed room here in Washington, D.C. to maximum capacity, and several hundred people on the telephone, over 400 of you registered total, so we're very pleased to see that and hope to deliver a terrific presentation for you today. A few logistical items, questions, as always. Well, actually, not as always. Sometimes we take questions throughout. Today, based on the size of today's crowd, both in person and on the phone, and based on the large amount of material that we need to cover, we're going to ask you to hold your questions until the end. For those of you in the room, just make a note of your questions, and we'll have some opportunity at the end of the program to take those. And for those of you on the webinar, please send me your questions using the chat feature on the webcast software at any time during the webinar, and I'll pose those to our speakers later on at the end of the prepared presentation. As always, this presentation is being recorded and will be available on our website on Monday. And in addition, all of you who have registered for the program will receive an email on Monday that contains a link to the recording along with the streaming PowerPoint presentation to colleagues and others who you think may benefit from the program. In terms of handouts, those of you in the room have, as always, the printed handout book that has a copy of the PowerPoint slides, the additional articles and other handout materials, and full bios for our speakers. And those of you on the webinar will receive on Monday, again, that email that contains all of that information, and you should already have a copy of the PowerPoint slides. Upcoming programs, we have two scheduled. December 5th, our program is entitled Work and Family, What Nonprofit Employers Should Know About Family-Oriented Employment Laws. That program is going to be led by two of my colleagues in our Labor and Employment Group who work very regularly with our nonprofit clients. A very interesting program which I think you'll really enjoy. And on January 15th, what is probably the hottest topic right now in the nonprofit legal community, fraud and embezzlement. Our program is entitled Protecting Your Nonprofit from Fraud and Embezzlement, Best Practices, Common Pitfalls, and Practical Tips and Strategies. We're particularly excited about this program. Timing is not coincidental. We did put this program together in the aftermath of the October and beyond Washington Post investigation and follow-up articles about fraud and embezzlement in the nonprofit community and the reporting or lack thereof sometimes of that fraud and embezzlement on the IRS Form 990. This article and this investigative series led by Washington Post reporter Joe Stevens has generated quite a bit of controversy in the nonprofit world. It's created a lot of buzz on Capitol Hill, a lot of interest. It sparked some congressional inquiries and investigations. And this is a story that's not going away soon. This is an area that we have for many years been speaking on, writing on, and counseling our nonprofit clients on fraud and embezzlement. This program is going to be led by my colleague, Widge Devaney, a former U.S. attorney with extensive experience in this area working with nonprofits. It's also going to have Joe Stevens, the investigative reporter for the Washington Post, who headed up that effort. Joe has agreed to participate on our panel, which should be a really interesting component. And then finally, we're going to have a fraud expert from BDO join us as well. Our speakers here today, we're very fortunate to have three very distinguished speakers. Two of my colleagues, to my far right is Bob Waldman. Bob, in addition to being a preeminent nonprofit tax lawyer, extremely experienced in the field, also serves as our firm's co-managing partner. I don't know how he does it all, but Bob is a terrific lawyer, extremely knowledgeable in this area, and I'm excited for you to be able to hear from him today. To Bob's left is Yossi Ziffer. Yossi is an associate in our nonprofit practice. Both Bob and Yossi are based in our Baltimore office, focus their practice almost exclusively on 501c3 organizations, public charities, private foundations, and the rest. Yossi does extensive work in this area as well, and he's going to focus on gift acceptance policies this afternoon. And finally, to my immediate right is Dick Larkin. Dick is, quite frankly, a legend in the nonprofit accounting community. Dick is technical director for the not-for-profit auditing and accounting at the BDO accounting firm based in the Washington, D.C. area. Dick is someone whose reputation precedes him. He's one of the preeminent experts in this area, and he literally wrote the book on the accounting, some of the accounting standards that Dick's going to be talking about here today. He's the author of the 4th, 5th, and 6th editions of Financial and Accounting Guide for Not-for-Profit Organizations, the 1st edition of Financial Statement Presentation and Disclosure Practices for Not-for-Profits, published by the AICPA. And for close to 15 years, he's been the author of Not-for-Profit Gap, as well as numerous other articles. We're very pleased and excited to have Dick Larkin here with us today. Full bios for our speakers are in your handout materials. So with that, without any further ado, let me turn it over to Bob Waldman to get us started. Bob?
Or a piece of land and says it can only be used for a particular purpose, a scholarship that can only be used for a particular group of students. Those are classic restrictions. Also, you're probably familiar with investment restrictions on gifts. Someone gives some asset to a charity and says it can only be invested in stocks, or it can only be invested in bonds, or says, I want you to hold the particular investment that I gave you in the form it is. A third common restriction that you see on gifts is a holding period, and that is on the ability of the recipient to transfer or how long the recipient has to hold the gift. And classic examples of that are someone gives artwork and says you have to hold on to the artwork, you can't sell the artwork. Undeveloped land, you give a piece of land to an environmental organization and you say, I don't want it developed, I don't want it subdivided, I don't want you to build on it. Classic restriction. Also think about a gift of closely held stock that inherently is restricted because the closely held stock may be subject to a shareholders agreement or may have provisions in it that prohibit the transferee from selling the asset. Common restriction. Think about endowed gifts. Someone gives you something that says you can only expend interest, you cannot expend the principal. And the most common restriction probably on a gift is naming. I'll give you something and I want it named, etc. So then let's talk about some basic concerns that come up dealing with these restrictions. Probably the one that it comes up more often than you'd think, and I think about this a lot when I see a restricted gift, but is what impact does the restriction have on the ability to take a charitable deduction for the gift? Because if the restriction is too severe, the IRS may say, well, wait a minute, you never really gave the gift away. You've restricted it in a way that you really didn't give it away, and that's going to adversely impact your deduction. Let's think about that. The cases, and you've heard of these, you've seen them, someone gives a piece of artwork to a museum and says, here's this piece of art, but I want the ability to use it when I want. If I'm going to have a dinner party in my house, I want to be able to take the piece of art back and put it in my house. We had a case not long ago where somebody gave a sculpture to a university, but required that it be placed in an area where no one would see it. And you see, I'll tell you where you see that one comes up all the time. You see a bunch of neighbors, and they all contribute their backyards to a land trust or environmental concern, so it protects their backyards and they get a deduction, but nobody else can see it. If you're going to throw the public, you can never see it. So query, have they really given anything away? So that's a major concern. Are the restrictions so severe that the IRS would say, you haven't really given it away? Now, it also, and Dick will talk about this shortly, whenever you put restrictions on gifts, it raises accounting issues. How's it going to appear on financials? Is it going to be temporarily restricted, permanently restricted? How's it going to impact on the ability of the organization to raise funds in the future, depending on how those appear in the financials? And again, Dick will talk about that shortly. Think about the impact that the restriction has on the tax-exempt status of the organization. Let's say somebody puts a restriction on a gift that's really inconsistent with the 501c3 status of the recipient organization. And let me give you some examples. I make a gift to a charity, and I say, here's a gift, but you know what? You got to use that gift to employ my son, my ne'er-do-well son. Well, that's going to impact on, and I've seen this case where somebody made a gift to a hospital and said, here's the gift, hospital, but you must use it to fund this particular research. Well, guess who was conducting that particular research at the hospital? The donor's child. That could impact on the hospital's 501c3 status. You've seen cases like this where somebody makes a gift to, there's a famous case where, and it's fairly recent, somebody made a gift to, I think it was a retirement home, and said, here's this huge gift, but you can only use it to take care of white patients. So if you take it, and it was a big gift, it could impact on your 501c3 status. So you have to think about, will that restriction adversely impact your tax-exempt status? Think about, and this is the worst case scenario in a way, that the restriction results in the donee getting sideways with the donor. So the donor puts a restriction on the gift. You're so grateful you take the gift, and then you say, geez, we can't follow that restriction. You know, that doesn't work for us. And instead of being in good stead with the donor, you're now sideways with the donor. There's a case, I had a matter a number of years back where somebody had made a gift to a charity and said the restriction was you had to use the money to support women field hockey players with Olympic aspirations. Well, in that particular geographic region, there weren't any. But they took the gift, but we couldn't comply with the gift. So you get sideways with the donor. And finally, think of the embarrassment that sometimes comes when you take a gift with a restriction and then you realize this is a really embarrassing restriction. Example, a case where we took partnership interests and they weren't marketable. We couldn't sell them. There was no market for them. Charities holding the partnership interest. About a year, 18 months after we're holding the interest, we sort of like, someone says, you know, I wonder what's in that partnership. What's in the partnership? The charity now owns several adult entertainment sites. Kind of embarrassing, couldn't get rid of the gift because it wasn't marketable. So, where does that take us? Well, let's talk about some recent donor intent cases that have gotten a lot of publicity and they give good examples of the do's and the don'ts here. Now, this one I always am a little reluctant to talk about because as soon as I mention Princeton University, there's always somebody in the audience who either went there, wanted to go there, the kid's there, they live there, whatever. But I'm gonna risk that one. So, because this case has gotten a lot of publicity. I think it was the Robertson family who are the founders of the A&P, A&P shopping chain. So they make a gift to the Woodrow Wilson School at Princeton to fund graduate students in preparing in their careers in the Foreign Service. And the gift grew. I think it was originally, if I remember, about a $30 million gift that had grown to $900 million. The family sues and says, Princeton has misused this money because we put restrictions that it was to be used to educate graduate students in the Foreign Service. But the way Princeton interpreted that, the family felt was too narrow. And they also didn't like the investment manager that Princeton was using. So they sued. And the lawsuit went on and on and on. And finally, it was settled a couple of years ago where Princeton ended up settling the case by paying $40 million in the plaintiff's legal fees. So you got to love lawyers. They did well here. And $50 million they gave the family to start a new foundation and kept the rest. Second recent case, and this has gotten a lot of recent publicity. This one involves Johns Hopkins. And here what happened, it was a bargain sale of real estate. And the family they sold for, I think it was for $5 million. If I remember, I think the land was appraised for about 10 times that number. But they sold it to Hopkins for $5 million. It was a farm. And they said, it was a two-page agreement. Obviously, they didn't use the $40 million lawyer. They got the cheaper lawyer. But it was a two-page agreement. And the two-page agreement said, here, you can have the land, Hopkins, and you can, use it and keep it, and you can, quote, unquote, develop it for I think the language was you could develop it for some sort of medical facility. And the question became, what did that word develop mean? Because Hopkins said, we're going to develop it into what I think they called Science City. And the family came back and said, that's not what we had in mind. We didn't want this developed, so they sued. And it's gone through several court hearings, and recently the court ruled in favor of Hopkins and said, well, sorry, donor, but you said in this 2-page agreement it was you could develop it. That's all you said. And if you had more specific concerns, you should have said them. But this was a normal real estate deal. You sold it to them for $5 million. You said they could develop it. That's exactly what they did. Shame on you. Third recent case, and this had a big write-up in the Wall Street Journal not long ago, and it involves the Ipswich public school system. And here, it was literally a 350-year-old trust that they were debating over. And under this 350-year-old trust, somebody gave this real estate to the Ipswich school system and said, here, you got to use this real estate to benefit the school system. Well, what happens over 350 years is a lot changes. And the real estate, where it was undeveloped at the time, 350 years later, is highly developed in the area. So the trustees of the charitable trust say, we're going to sell this real estate. I think they're going to sell it for, about $32 million. So they go to sell it to the people who live around there. The lawyers come running in, lawsuits left and right. You can't. The thing says you can't sell it. I realize life has changed in 350 years, but you can't sell it. And the most recent case, and I think this is a really important case, it's a New Jersey case. It was just maybe a couple months ago. And here's what happened in this case. The donors, animal lovers, give $50,000 to an animal shelter to expand the animal shelter, to build some large cages for dogs and cats. And what happens is the animal shelter, after they get the $50,000, decides to merge with another animal shelter. So they go back to the donors and say, you know what, we're merged and we're not going to build that expansion. We're not going to build those additional cages. We're not expanding, we just merge. But we'll tell you what we'll do. We're going to take that $50,000 and we're going to build a new, smaller facility in a different town. The donors sue and say, wait a minute, that's not our deal. We said we're going to expand the facility in our town. We didn't give you $50,000 to build a new facility. So it goes to court, and the judge says, you know what, charities, you can't use bait and switch. You can't say, if a donor puts a stipulation on a gift, you can't switch it. And they made the charity give the $50,000 back. Now, you see that issue comes up a lot if you're doing a merger of charities or a reorganization of charities, and you see this happen all the time, the assets that are going over to the new charity may have restrictions on them. And you've got to worry about, I gave my money to charity A, now they're going to merge with B, or they're going to transfer their assets to B. Does that asset necessarily go to B? That's not what the donor wanted. The donor wanted it to go to A. So in those cases, obviously your best scenario is you go back to the donor and seek their approval. If you can't find the donor's gone. Maybe you go get Attorney General approval. Maybe you get court approval. But you see that come up a lot. The other time you see it come up is in the financing arena. Because what happens now, if you're like a college and you're doing financing, quite often they'll ask you to pledge the endowment, or they'll ask you to pledge certain funds you hold. But those funds may be restricted. They weren't intended to be part of the pledge. So you have to worry about, am I violating the donor intent when I pledge those assets to build the new dorm? Again, you might look for donor consent. You might look for the AG. Now, let me talk about a particular law that's out there called UPMIFA, and some of you may be familiar with this. UPMIFA, the Uniform Prudent Management of Institutional Funds Act, which, as you all know, replaced UMIFA, the Uniform Management of Institutional Funds Act. But what does UPMIFA do? UPMIFA is a uniform law that has now been adopted in virtually every state in the U.S. And it's slightly different from state to state, but it's more or less the same on its important points. And what UPMIFA does is it permits a charity to deviate in the management, investment, or purpose of a gift with these stipulations. You can deviate from the gift if you get donor consent, or if that's not possible, with court and attorney general approval. And what's really interesting about a MIFA is it permits you to appropriate principal from an endowment even if the gift said you can only expend income. Because what a MIFA was trying to do, and when it was enacted, was, if you remember, when the economy collapsed in 2008, and there were all these gifts out there that said you can only expend income. Well, the gift was now, half of what it was when they gave it, so there's not enough money to do what the donor intended. So what the Uniform Act said is, look, that's not what the donor wanted to do. The donor wanted you to be able to use the money to do good things, so we're going to let you invade principal under certain circumstances. So that's a very important law to familiarize yourself with. All right, so what are the lessons learned from these recent cases? Number one, most important, is that gift agreements need to be very, very clear, and that's the Hopkins situation. If you don't want someone to develop it, the gift needs to be clear about what do you mean by development. And what we've learned over time is, I've seen gift agreements recently. There are as many as 38 pages that have what about this condition, what about this condition, what about this one? Second, leave room for flexibility. Times change, circumstances change. You've got to think about, if you're the charity, what are you going to do if things change? You agree to the stipulation now, but what if there are no field hockey players out there? What if the land is all developed around this underdeveloped land you hold? Do you still want to hold it as raw land? So think about that and consider the possibility of changed circumstances and what do you want to do with that. So let me stop there. I'm going to now turn this over to Dick to talk about some of the accounting issues that go in this area.
Thank you, Bob. I can give another couple of examples of interesting cases, one involving changed circumstances, and this was a formerly all-girls college in Massachusetts that had donors, of course, who donated to it, all women, naturally, and they went co-ed. And all of a sudden, they started getting communications from some of their donors saying, wait a minute, I gave a gift to educate women. I don't want my money used to educate men. I want my money back, or whatever. So did their entire fund balance or their entire net asset balance suddenly become donor restricted for paying for women's education when they went co-ed? Again, I think the lawyers in a court had to sort that one out. And there was an interesting one on naming rights where the University of Minnesota was approached by a donor, offered to give them $20 million to build a building, and the stipulation was that the donor's name had to appear on the building, the John Smith Memorial, whatever. Well, the university did a little research into the background of this guy, discovered that his name was not one they wanted splashed around on their campus. They turned down the gift. $20 million that they turned down because they could not live with the donor's restriction. Or another case like that involved Yale University. They were offered $20 million to endow a new academic department with a restriction that the donor have veto power over the appointment of the academic chair of that department. Now, no university worth the name is ever going to allow an outsider that kind of academic influence over the university. Obviously, they tried to negotiate with the donors. The donors were, in fact, a very, very rich family, not Bill Gates, but in that, that realm. They tried to negotiate, but the donors were adamant. Again, Yale had to turn down the gift. They simply could not live with that donor restriction. So that's some more examples of the things Bob was talking about. Okay, I'm going to talk now from the accounting point of view. You've got a gift. The gift may have restrictions on it. What does that mean for how the accountants take care of it? First off, it is donor restrictions that make contributions very complicated to account for. Accounting for contributions, and I've given you the citations in the accounting literature where you can find all of this, it is one of the most complex areas in all of accounting. And I don't just mean nonprofit accounting, I mean in all of accounting. It ranks right up there with things like LIFO inventory, foreign currency translation, computing earnings per share, all of the things that CPAs prayed would not be on the CPA exam the year they took it. Well, contributions are right up there with all of those guys. So what is especially complicated with this is distinguishing between a donor restriction and a donor condition. And they sound a lot alike. For example, I promise to give your museum $10,000 if you put on an exhibit of Monet paintings. Okay? How about, I promise to give your museum $10,000 for your exhibit of Monet paintings. Notice how similar those two phrases are. I promise to give your museum $10,000, blip, 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 exhibit of Monet paintings. Just a few little words in the middle there, and yet you realize that creates two entirely different stipulations, and the accounting rules for those two are also entirely different. Read the language. Bob said this, read the language very carefully because that is one of the most challenging parts of the accounting for this. So the general rules, and this applies to all types of contributions now, revenue recognition, the timing for an unconditional gift or pledge is when the gift is made, or in the case of a pledge, when the gift is communicated to the donee. Sometimes you get into interesting judgments about when has the communication occurred. If the charity gets a letter in the mail on January 2nd, postmarked December 31st, was that communicated in December or not until January? These are things that organizations need to have policies about. And again, when in doubt, consult your attorney, because most of the things I'm going to talk about are basically legal questions. They have accounting implications, but they are fundamentally legal questions. And when you have doubts, when you're uncertain about how to handle some of these things, the person to go to, well, first go to the donor if you can, if the donor is accessible to you. But if you can't get to the donor, or if the donor is still maddeningly vague, then you will want to consult an attorney. So unconditional gifts when they are made or communicated. A conditional gift, that is a gift with an uncertain future event that has to occur, such as a matching gift, then it is recorded by the charity as revenue when the condition is substantially met. And again, substantially is one of those weasel words that you find in accounting literature that occasionally will call for an interpretation to be made. So that's the timing. Valuation, the accounting rule is pretty clear here that all contributions are valued at the fair value at the date of the gift. Now, fair value is itself a sometimes vague term. As I note here, this can be challenging for non-cash gifts. Cash, marketable securities, no problem. Real estate, artwork, oil and gas interests, non-publicly traded stock. Sometimes you may have to get appraisers to appraise the value of these things. Valuing some of these things can be very challenging. Again, you may need expert help, and don't take this lightly because this can be a serious issue.
Dick, can I stop you for a second? Would you mind just commenting on the valuation issues? It's in an area that, as we all know, has become a very, very hot area with respect to the IRS. What obligation, role is there for the nonprofit, the recipient, in the valuation process?
Good point. There are obviously three parties to this. There is the donor, there is the recipient, and there is the Internal Revenue Service. Now, the recipient is mostly not particularly concerned with the Internal Revenue Service. I mean, obviously, you have to file your Form 990 and report these things, but the IRS is not about to get uptight with the recipient of a gift over valuation issues. It's the donor who, of course, is concerned about whether or not the IRS is going to challenge the value that is used to take a tax deduction. The charity, of course, is concerned about the value that goes on in their accounting records. Question often comes up, should the charity provide the appraisal to the donor? And the rules here are, first off, fairly clear that for the donor's tax deduction purposes, the charity may not be the appraiser. The donor is required to get an outside independent appraisal. This is for gifts of non-cash gifts valued over $5,000. The charity, obviously, it's a free country. The charity can tell the donor anything they want, but the donor is not going to be able to use a communication from the charity as support for their tax deduction. They need to get an outside appraisal. Furthermore, I strongly advise charities not to tell the donor what the charity thinks something is worth, because if and when, more likely when, the donor gets into a spitting contest with the IRS over this issue, the IRS will ask the donor, well, who told you that thing was worth $50,000? And the donor will say, well, the charity told me it was worth. IRS will say, okay, get the charity guy in here. I want to hear it from him. Well, you're the charity. You now are in the middle of a spitting contest that you don't want to be in the middle of. You have no good outcome of this. If the donor's deduction is disallowed or partly disallowed, who's the donor going to be unhappy with? The charity. You told me it was worth $50,000. Blah, 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 blah. So as to use Bob's term, you are now sideways with your donor, and that's not a situation you want to be in. So it is the legal responsibility of the donor to get their own independent appraisal when they are taking a tax deduction for non-cash gifts.
Dick, just a couple quick follow-up questions, because I know this is a really important area. What obligation is there on the recipient charity to do any due diligence on the appraisal or to question the appraisal, particularly if the appraisal raises some red flags, seem to have some real holes in it, some questionable theory behind it? Any obligation on the charity to do anything, or if it comes from a qualified appraiser, then accept it as is?
I would say there is no legal obligation for the charity to do something. I would say there is sort of a moral obligation. The charities obviously don't want their donors to get sideways with the Internal Revenue Service. And if the charity sort of senses that the way things are developing here, the IRS is likely to challenge this, the donor is likely to end up getting their deduction partly or completely disallowed, the charity, I think, has a moral obligation to at least warn the donor, look, donor, this is starting to look like you may be headed for trouble. You may want to get a second appraisal, or you may want to rethink whatever. Because, again, you don't want your donor to be unhappy as a result of this whole process. But no, there's no legal obligation. The legal obligation for the charity is to make sure that the amount it records in its own financial records is the fair value at the date of the contribution. Now, is the donor going to find out what you put in your accounting records? Maybe or maybe not. If the donor is on your governing board, they're obviously going to see what goes into your financial statements. If the gift is a really, really big gift, then the donor is probably going to realize what number you used, and if the number you used varies a lot from the number they think is right, again, talk it over with them. Work this out, hopefully before they file their tax return, before you prepare your financial statements, so that at least everybody understands where everyone else is coming from. And if you end up with a disagreement on the amounts, well, then so be it. Again, it's up to the donor to deal with the IRS if it comes to that. The charity's obligation is to prepare its own financial statements in accordance with generally accepted accounting principles, which say fair value at the date of gift. And the accounting literature now is full of guidance on determining fair value. That's not the topic of today's talk, but there is a lot of guidance now in the accounting literature that charities should use in determining fair value.
And one last question. What tax reporting obligation is there on the recipient charity? Any tax form that has to be provided to the donor?
There is a tax form. The tax form, the responsibility for the tax form is 100% the donors, well, 99% the donors. The 1% for the charity is the charity has to sign the form acknowledging simply physical receipt of the gift. When the charity signs that form, and it's IRS Form 8283, and when they sign that form, they are not attesting to the fair value of the gift, which will appear elsewhere on the form. The charity is merely acknowledging, yes, we did get this item, and the description of the item will be on the form, from this donor, and that's all they are attesting to. The charity should sign that form, keep a copy of it, of course, give a copy to the donor. Technically, there is no legal obligation for the charity to sign that form, but obviously if the charity doesn't sign it, now you're definitely going to be sideways for the donor. So you want to do that. There is one form that the charity does have to sign. This is a legal obligation. This is Form 8282. If you have a gift where you signed an 8283 and the charity disposes of the gift within a certain time period after receipt, then they must provide the donor and, guess who, the IRS, with a form that says, in effect, we got this gift from this donor and we disposed of it, and guess what? Here's the amount we sold it for. Now you see where the implications of that are headed. If the donor has taken a $100,000 tax deduction and a year later the charity turns around and sells the item for $10,000, guess who is about to get a rather unpleasant visit from the Internal Revenue Service? I call this the tattletale form, because that's essentially what you're doing. And so if you're the charity and you are receiving these kinds of gifts, and think museums and the like here, if you are going to be likely to dispose of the gift, it is only fair to warn the donor, hey donor, thank you very much for your gift, but we already have 10 paintings by that artist in our museum. We're going to sell the painting, use the proceeds to buy other artwork, and when we sell it, we are going to have to advise the IRS of what we sold it for. And again, leaving it up to the donor how they're going to react to that. It's up to them to substantiate their donation, the value of their donation.
One last question that certainly comes into play in a lot of these situations. Quid pro quo contribution. So the donor is giving a contribution but getting something of value in return. Real briefly, just can you explain basic rules in this area and what obligation there is on the charity to report to the donor?
There are responsibilities here where a quid pro quo, and this could be the gala dinner dance where you pay $500 a plate, and for that $500 you get dinner and an evening's entertainment worth maybe $100. It is the responsibility of the charity to advise the donor of the fair value of the stuff that the donor got in exchange for the gift. And by the way, it's the fair value, not the cost to the charity. Maybe the hotel has comped the dinners to the charity because the hotel is feeling charitable. That's fine, but the donor has still gotten dinner and dancing worth $100, and so the value to the donor is still $100. There is a de minimis threshold. Gifts under $75, you don't have to worry about it. Or if the value of the item is less than about $10, and that value varies each year, then they don't have to worry about it. But for bigger gifts, there is a legal responsibility to advise the donor of the amount that they cannot deduct because it's something they got in return for the gift.
Promise is the last question, but a corollary question. If a donor is making a big donation and they're getting some naming right, they get their name on a wing of a museum, they get their name on the outside of a building, does that have to be valued for purposes of a quid pro quo? Is that considered a quid pro quo contribution?
Yes and no. Yes, it is a quid pro quo contribution. No, the IRS has said, in effect, we're not going to go there because they know perfectly well that if you tried to put a value on naming rights, they would end up in endless litigation with donors. Let's face it, there is no way to put a value on naming rights. So the IRS has, in effect, said, don't worry about it. We're not going to require you to reduce the value of your donation because of naming rights. Sure, there is a value there, but anybody in this room knows how to come up with one. I'm sure all of us would be interested, but I sure don't know how to do it.
Thank you.
Okay.
You can go back to your presentation.
Next point on the slide, contribution. Because I said the timing of the revenue recognition was when it is made, if it's unconditional, or when the condition is met, if it's conditional, the implication of that is that contributions are never recorded in the financial statements as deferred revenue. They are always either revenue, if they're unconditional, or not recorded at all if they are conditional. And therefore, unlike previous accounting rules that existed before 1993, you will never see deferred contribution revenue except with two rather uncommon scenarios that I've noted on the slide there. A refundable advance, that of course you have the asset, so therefore you have to record that offset by a liability, and a certain type of split interest gift called a pooled income fund. That does result in deferred revenue, but these are rather uncommon. It's the norm that you do not record these as deferred revenue. Now, the types of restrictions, you get basically three types of restrictions. No restriction, temporary restriction, permanent restriction. Those three terms mean precisely what they say. There's not any arcane bit of understanding. Just take those terms at face value. However, just for the record, FASB is currently debating the question of financial statement format for nonprofits. A tentative decision, this is tentative, it's not final, not been promulgated, it's not GAAP, don't do it yet, but you're probably going to see this coming down the pike within maybe a couple of years. The two restricted classes are likely to be collapsed into simply restricted. There will still be disclosure, of course, but at least on the face of the financial statements, we're probably only going to start seeing unrestricted, donor restricted, with footnote or other disclosure as to how the donor restricted class actually breaks down. There is a special rule where you have a temporary restriction and you meet it in the same accounting period. You are permitted, this is an option, but you are permitted to record that directly as unrestricted rather than run it through temporary and then out of temporary. But if you do this, you have to be consistent for all such restrictions. Note also, the word restricted has a particular meaning in accounting, and that meaning is different from the meaning that my colleagues up here would ascribe to it. There are legal restrictions, there are contractual restrictions. That's the ones these guys deal with. Donor restrictions are the ones that accountants deal with. And so the use of the word restricted in accounting is used only to refer to contributions, not other types of revenue, just contributions, with a donor-imposed restriction on the contribution. Revenue, other than contributions, with only legal restrictions or contractual restrictions of some sort, are reported in the accounting records as unrestricted. Now, what you jolly well better do in those cases, though, is to have adequate disclosure so that the reader of the financial statements understands that, yes, this is in a column headed unrestricted, but it is not just available for any old thing the organization wants to use it for. It can only be used in accordance with this contract or this law or whatever. Also, restrictions in accounting apply to net assets, that is equity or fund balance, it used to be called. Sometimes, not often, but sometimes a donor will put a restriction on a particular asset. Bob talked about some examples of those, but those are less common. Usually a donor restriction will run only to the net assets or equity rather than to individual assets. Now, what really makes accounting for contributions complicated, next slide now, thank you, is that there is an awful lot of judgment involved. Much of accounting does not actually involve a whole lot of judgment. Much of accounting, especially pretty much all accounting in the business world, is fairly cut and dried. There are particular rules. Some of the rules are rather complicated, like LIFO inventory. It's a very complicated set of rules, but the rules are there, and they are pretty specific, straightforward. You just plug in the numbers, crank out the answer, and there you are. There's very little judgment involved. There are few cases in the business world where judgment has to be applied. One would be for uncollectible receivables, that is an allowance for doubtful accounts, as they call it. Another would be contingent liabilities. You may be on the hook for something, you're not sure. Even if you are, you don't know how much you're on the hook for. Businesses have those. Those are about the only two judgments that you normally find in business accounting. Now, nonprofits have those too. But nonprofits also have a whole flock of other judgments that you don't find in the business world. Why? Because businesses don't get contributions, right? When was the last time any of you made a voluntary contribution to your local electric utility? I didn't think so. Okay, but nonprofits get contributions, and they come with sometimes conditions, sometimes restrictions, sometimes both of the above. There are other issues that come up in accounting for contributions. The first one, for example, is it a contribution at all? Or is it simply an exchange transaction? Is the payor, I'll call this person now the payor, not the donor, are they getting basically fair value commensurate with what they paid? In that case, it's probably an exchange transaction. It's not a contribution at all and follows a completely different set of accounting rules. Next issue that sometimes comes up, was it really a contribution to this organization? Sure, the donor paid something to somebody that furthers your mission, but they didn't pay it to you, and you really weren't in the loop. Sure, you're glad they did it, It's helping you achieve your mission, but it wasn't a contribution to you. And that is a judgment that you sometimes find yourselves having to make. With pledges, the accounting literature is pretty specific. To record a pledge, it has to be a promise, not just some intention, wish, hope, plan, thought. It has to be a promise. And again, we get now into parsing the language. What does "the" mean here? Bob talked about some of that. That comes into play where you're dealing with pledges. You have to look at the language, ask yourself, is it really a promise? Conditional versus unconditional. Is there an uncertain future event? The matching gift or challenge grant is the classic conditional pledge, but there can be lots of other conditional pledges. I could make a pledge to your charity conditioned upon there being at least 20 inches of snow recorded at Reagan Airport this coming winter. How uncertain is that? Well, you'd have to look up the weather statistics. 20 inches actually would be fairly uncertain, at least in recent years, except about 3 years ago when we had 60 inches. So is that a condition? Well, it probably is. If I said, however, 1 inch of snow, now that's probably not a condition because we get at least that much snow pretty much every winter. So again, you have to judge, is this really a condition or not? How uncertain does it have to be? Again, you're going to be using your judgment.
Actually, Dick, before we move on to the next slide, it might be helpful if you or Bob or Yossi or myself give an example or two for each of those first 3 bullet points in particular, just to help illustrate, because I think they are important points to stress.
The one that comes up with the contribution versus exchange in most of the time is government grants. Governments do make grants that are contributions. That is, the government itself is not getting a quid pro quo. But many government grants, such as research grants, are often exchange transactions. It is the results of the research belong to the government. And so therefore, the charity is not really, it's often a university or something like that in that case, they are really simply being hired on a contract basis to do a function for the benefit of the payor, the government. I mean, sometimes private foundations do that. Rarely would individuals do that. It's usually governments. But in each case, you have to judge, is the payor getting a quid pro quo here or not?
And another, the term donative intent, which is one of the requirements to take a charitable tax deduction, comes into play. When you make a payment of tuition to the tax-exempt nonprofit college that your child's going to, you're getting presumably full fair market value in return. And even though it is a tax-exempt 501c3 organization, much of the time you're not able to take a charitable tax deduction. Whereas if you, as an alumni, make a contribution to the University Alumni Fund, and you're not getting anything in return except for maybe a little token item or something, that does have donative intent, and you can take that tax deduction.
Unless, of course, as Bob said, it's donation to a scholarship fund for the benefit of your children. Now they're definitely not going to allow that deduction. Talking about tax deductions, though, if it is an individual, then of course it becomes a real concern. If the payor is the federal government, they are obviously not concerned about tax deductions. If the payor is a business, a for-profit business, they will probably get a deduction in any case, either as a charitable contribution, if that's what it is, or if they are simply making a payment on a contract basis for exchange, they'll take it as a deduction for a business expense, and so they'll get the deduction any way around. So it's with individuals that you really have to be concerned about whether or not, for tax purposes, whether there is an exchange there or not.
And that is an important point to stress, that generally speaking, how the donor treats the payment for tax deductibility purposes is not necessarily and generally is not tied to how the charity treats it. So for instance, a corporate sponsorship payment, which may be paid by a business out of its advertising and marketing fund, and it's going to take a business tax deduction for that, usually is going to be treated as contribution income by the recipient, assuming it's falling within the corporate sponsorship exception to unrelated business income. So even though the business is taking a business tax deduction, the charity is treating it as contribution income.
It is, however, definitely worth it for the charity to want to understand how the donor is going to be treating it. You just heard Jeff use that magic phrase, unrelated business income. Contributions are never unrelated business income. They are exempt by law from being taxed as unrelated. Exchange transactions, however, are theoretically always subject to being treated as unrelated business income. if they meet all the complicated rules. Again, not the subject of today's session. So if the donor is going to be treating it as a business expense, the charity may very well want to have their tax advisor talk to the donor's tax advisor to make sure, again, everybody is on the same wavelength so that the charity doesn't end up getting hit with a bill for taxes on unrelated business income, when in fact it really would be better off being treated as a contribution or as some kind of related business income which would not be taxable. So again, communication all around is key to this. Jeff asked about the second bullet, to or for the benefit of this organization. The example I always use when I teach this is, let's say I am very militant, have very militant feelings against smoking. And so I go down to the Washington Post over here on 15th Street, and I give them a check for the payment for a full-page ad in which I lay out all the medical facts about how, you're going to die from heart disease and cancer and all that stuff if you smoke, and here are the statistics, and the statistics were provided by the American Cancer Society, and you really shouldn't be smoking, so please don't. And the Washington Post runs the ad. I paid the Post for it. Have I made a contribution to the American Cancer Society? No, because they weren't in the loop. Now, if I went to the American Cancer Society and said, hey, if you guys would like to run some ads in the newspaper, let me know how much it is and I'll write you a check. Now they are in the loop, and they would record that as a contribution. But if it's just between me and the Washington Post, the American Cancer Society has, sure, they're happy I did that. I'm helping them further their mission by all means, but they don't get to record a contribution. If they did, then probably also the Heart Fund, the Emphysema Society, the American Lung Association, the Sierra Club, everybody would get to record contributions because, of course, all of those guys are hoping that you'd stop smoking to keep the air cleaner, even if it's not for your own health. Let the air be clean for the rest of us. The promise versus intention, you really just have to look at the language. I'm thinking about making a contribution. I might make a contribution. I hope to make a contribution. I plan to make a contribution. I will make a contribution. I promise to make a contribution. You see, I'm moving along a continuum here, and somewhere along that continuum you make a cut and say, okay, all of these guys over here don't qualify as pledges for accounting purposes. These guys over here do. And that's where you have to parse the language.
And Jesse's going to talk about this in some of his remarks, but that's where your lawyers can be extremely helpful, because if you get some kind of a pledge that's written by the donor and it is unclear, it's often very possible. In fact, the norm is that the donors are going to be willing to work with you to make that clear and to fine-tune the language, and you should be regularly working with your counsel to help provide more clarity in those documents.
I always stress when I talk on this topic, and I've talked about it to groups of professional fundraisers, I've talked about it to United Ways, I've talked about it to groups of charities, talk to the donor before the gift gets made. If you have a donor that you sense is about to make a gift to you, get with them and get your CPA and your attorney and their CPA and their attorney and the professional fundraiser, get them all in a room together, work out who's going to say what to whom, what the timing is going to be, how everybody's going to be recording it, treating it for tax purposes, so that when the actual gift is made, there are no surprises. What you don't want is surprises. The donor doesn't want surprises. The charity doesn't want surprises. Get it all planned out in advance before you actually make the gift.
Dick, let me ask you a quick, I know we're running a little long, so I want to, but what I've seen a lot of recently, given the economy, is people who've made multi-year pledges to a charity and then can't make the pledge. They can't make the gift. They don't have the money.
Yeah.
When you book the pledge on the front end, is there any element of the creditworthiness of the donor, and does that weigh into the booking of it?
Yes, yes. As with any receivable, and this can be loans receivable to a bank or whatever, you always consider the creditworthiness of the donor. Now, this can be sensitive with pledges because obviously people are doing this voluntarily. They're not doing it in an exchange transaction. They're doing it out of the goodness of their hearts, supposedly. And you don't want them to get a sense that you have any question. What, you think I won't pay my pledge? Oh, shame on, now you're sideways with the donor again. But yes, you definitely need to consider the creditworthiness, and your auditor is going to insist that you consider the creditworthiness of the donor. Now, the scenario Bob laid out, you get a multi-year pledge in year one, and in year one everybody's fine, the donor is still financially solvent and so on. Year 3 comes along and the stock market has crashed and the donor's financial situation is now kind of iffy. This is where it gets really, really delicate, that you've got to be concerned. There are accounting rules for how you deal with that. You set up an allowance for uncollectibles up front, and then you tweak that allowance going forward as you judge necessary to allow for your current assessment of the likelihood that that donor will in fact actually pay the pledge that they've promised to pay. And there have been some interesting cases involving especially multi-year pledges that a couple of them have ended up in court.
Okay. Sorry for all these interruptions. I definitely need to wrap up this part.
Yeah, we need to move on here. Next slide, is it restricted or unrestricted? And remember, only the donor can restrict a gift. There are many people out there who think that a board can restrict. Boards cannot restrict. Boards can designate, boards can appropriate, they can set aside, they can put in a piggy bank, they can put in a separate fund, but a board cannot impose a legally binding restriction. Why? Because anything a board does, a board can undo. And therefore, accountants consider that a board so-called restriction, and I always tell people to avoid using that term, really has no legal standing. Definitely disclose board designations in your financial statements, but don't treat them as restrictions because they are not. Next judgment, when has the restriction been met? Usually this is pretty straightforward, but there can be questions as to whether or not the restriction has been met. For example, the Princeton University example that Bob mentioned, that focused right on this particular judgment here. There are other two things about volunteers that involve judgments that we don't have time to talk about, but they're in your handout there. So I'll leave them with you in the slide.
Yeah, we're going to probably have to glance over some of these slides and just focus on the ones.
Yeah, I'm going to go really fast here. Note that when I use the word judgment, I'm talking about qualitative judgments, not quantitative judgments. These are not estimates involving numbers. These are qualitative judgments about the nature of something. What is this really? And that's what I mean when I'm using the word judgments. What you need to do is to get inside the donor's head, and that's just my phrase for what Bob was talking about. When in doubt, ask the donor or an attorney. There are 4 areas where there are special rules that we won't talk about, but just know they're there. Pass-through gifts, donated services to volunteers, split interests, and gifts to museum collection items. If you're involved with those kinds of gifts, look in the accounting literature for the special rules involved. This is a visual that I created years ago to use as a teaching device to help you think about some of these judgments. Think about the continuum. Where are you along that continuum? And that will help you make the judgments that I have just been talking about. And here's a list of the various judgments involved in accounting for contributions. Now, the rest of my material is a list of factors. And this list of factors has 2 columns. Conditional versus restricted, which is one of the most difficult judgments to make. Go ahead about 3 or 4 slides here until you get to one with 2 columns in it. There. And I'm not going to go through this. This is something for you to take home with you and use. I hope it's helpful to you just to help you focus on making the various judgments that I've talked about. And with that, I will turn it over to Joseph.
Thanks, Dick. So in our remaining time, we're going to discuss gift acceptance policies. And conceptually, this is a little bit of a different angle, and it goes to the point that Dick mentioned a moment ago, because when it comes to questions of donor intent or accounting practices, those really come up primarily once the gift has already been made. The gift policy, on the other hand, really allows an organization to be planful and strategic throughout the life cycle of the gift process, really beginning at the stage of donor cultivation and negotiations and discussions with a donor, through the making of an actual gift, the holding of the gifted property, and then ultimately, in many instances, the disposition of that property. And so in that respect, the term gift acceptance policy is probably a misnomer or under-inclusive, because the well-drafted policy will focus not only on the acceptance of the gift, but really the entire process that surrounds that, as well as the disposition of the gift later on. And that becomes very important because for gifts other than cash or marketable securities, let's say the true value in the gift to the organization really may not be the gifted property itself at all, but really what you can get for it by disposing of the gift and then taking those proceeds and devoting them to the furtherance of the purposes of the organization. I'd like to divide our discussion really into three sections. I'm going to start with some general comments about gift policies in general, then discuss some internal governance issues that arise in connection with a gift policy, and then in the time at the end, we'll focus on some topics and issues that come up with respect to specific types of gifted property. So first, some preliminary general comments. And really the good news and the bad news is that there's very little guidance in this area whatsoever. There are no laws or regulations that apply to gift acceptance policies. You're not out of compliance with any rules if you don't have a gift acceptance policy. And what that means is that we find ourselves within the realm of best practices. And that affords an organization a lot of flexibility in terms of what goes into the gift policy and the role that the gift policy plays within the organization's operations and culture. Now, I said it's the good news and the bad news because it also means that we can't look to a specific checklist and say, well, in order to have a good or an effective gift acceptance policy, let me just make sure that the following items are in there, and then I'm home free. Rather, it puts the burden on the people who draft the policy, like the lawyers, to make sure that the policy is created in a way that really fits the organization's culture. And just by way of contrast, I'm sure many of you recall years ago after 9/11, Treasury came out with some recommended best practices to be used in the area of international grant making. And this created a whole firestorm of controversy within the charitable sector because all of these practices, many of these practices, even though they were just recommended and voluntary, organizations felt that they were really, this was too complex and nuanced an area to have a one-size-fits-all approach, and that certainly for smaller organizations, some of the procedures that were being recommended were completely unrealistic and out of whack with the human resources and really the capabilities of an organization to carry out those procedures. So when it comes to a gift acceptance policy, you don't have to feel any pressure that the policy is going to be burdensome or unrealistic in relation to your organization's structure. Really, it's a matter of thinking about what will work best, what will fit, and what will ultimately enable the organization to engage in the gift procurement process in a way that is helpful to the organization.
And yes, so I guess it goes without saying for you and Bob and myself, we always get questions from clients and others that say, hey, can you just send us a model gift acceptance policy that we can use?
Right.
Or can you send us a model investment policy? In certain areas, a model policy with a little tweaking can work for your organization. But in other areas like this, obviously this is a clear example where there is no model gift acceptance policy. And I know, we here at Venable have certain kind of starting point documents that have all sorts of provisions that are modifiable, deletable, et cetera, but it really has to be tailored for each organization.
Definitely, agreed. And so now that I've said that, let me tell you what a sample gift policy might look like. If we go to that slide. So very often an organization will open the gift policy with a statement of mission, a statement of purpose, and at first glance that may look superfluous or really unnecessary in the gift policy, but it does play an important role because it helps the folks involved in the gift process to really keep their eye on the ball and make sure that in the process of securing gifts, that they're doing it in a way that's helpful to the organization. there may be a tendency or an impulse to say, well, there's no such thing as a bad gift, right? If you're willing to give me something, then I'm only too happy to take it. But in some of the examples that Bob mentioned, you can see how gifts come with strings attached, and if there's certain set of expectations on the part of the donor, yes, I'd be very happy to give you this gift with the following 30 pages of conditions attached to it. The organization definitely wants to think twice about whether those conditions are workable, not only within its broad tax-exempt purposes, but also in terms of its own self-formulated priorities at any given point in time. And so those statements of philosophy or purpose at the beginning of the gift policy can be important to help keep that focus. After that, you may find an overview of different categories of gifts, and again, this goes to the topics that Bob and Dick have been discussing, discussion of the treatment of restricted versus unrestricted gifts, current gifts versus those that are made through bequests or established through trusts, and then the treatment of gifts of specific types of property, which might include cash, securities, tangible personal property, real estate, intellectual property, etc. And then the policy will also typically address procedural and administrative matters for the inner workings of the organization. And these topics might include the creation and function of a gift acceptance committee or some other delegation of board authority, organization practices regarding the gift reporting and accounting, as Dick has been discussing with us, gift publicity, donor recognition, other forms of quote-unquote donor rights that are associated with gifts, and of course the tax and compliance considerations that go along with receiving gifts. Now again, as we said before, there's no formula or mandatory checklist, so in any given policy, feel free to omit any of those things, or there certainly may be others that are worth adding for your particular organization. Now, with that overview in place, let's focus more closely on the issue of internal governance and those that arise in connection with gift policies, beginning with the use of a gift acceptance committee. And many organizations consider forming these types of committees either as a subset of the board, where the committee is composed entirely of directors, or perhaps made up of a broader cross-section of individuals, directors, professionals, as well as other volunteers. And if your organization expects to utilize a gift acceptance committee, then one threshold question to address is whether that committee is authorized to actually make decisions and take action, binding action, on behalf of the organization, or whether the committee is going to operate in more of an advisory capacity to the board, and the ultimate discretion and authority in terms of action remains with the board of directors.
And Yossi, just to interject, there are state corporate law implications to that too, because if you want to have, in certain states under the State Nonprofit Corporation Act, such as here in D.C., if you want to have a committee of the board that has the authority to take action on behalf of the board without the board later having to ratify that, there are requirements in terms of who can sit on those committees, often limited to directors only. So if you do want to have a committee that involves other folks beyond directors, be sure to consult your state law for your state of incorporation.
So, some questions to consider is whether the committee will exercise the authority to make final determinations on the acceptance or refusal of particular gifts, the formulation of organizational priorities in the area of gift acceptance, and also, once a gift has been made, does that committee then handle the ultimate disposition of the property, or once the gift has been made, do the investment and sale decisions then shift over either to a different committee or back up to the board as a whole? Now, as Jeff mentioned, particularly if the committee is going to be authorized to take action, then in addition to consulting with the applicable state law, another thing to be mindful of is to make sure that the organization's bylaws permit the creation of this type of committee, and that the anticipated role of the committee is consistent with the other provisions of the bylaws. And if your organization also has a separate governance or compliance committee, it might be worth involving that body as well, just to address those issues. Now, if the policy provides for a gift committee and spells out the committee's responsibilities, then in some instances the adoption of the gift policy itself may function in lieu of specific board resolutions. And what I mean by that is that rather than having to go back to the board to actually either through board meeting or unanimous written consent to authorize the committee or representatives of the committee to make a decision with respect to a particular gift at any point in time, if the gift policy itself is duly adopted by the board, then it can sort of function as a standing delegation of authority and authorization from the board. On a related point, another thing that's very helpful to address in the gift policy is not only the function of the committee, but also to establish a pecking order or a subset of individuals who actually hold signature authority on behalf of the organization. And this comes up sometimes in the case, maybe less so in the acceptance of gifts, although it could come up there as well, but certainly in the subsequent disposition of gifted property, there may be situations where in order to dispose of the property, someone has to actually act on behalf of the organization to sign a conveyance document or other agreements, things of that sort. And as we all know, invariably, if only one person is authorized, that person is going to be hard to get a hold of when these documents actually have to get signed. And so the gift policy may create a group of individuals who are authorized to execute documents on behalf of the organization in these types of situations. But again, just to keep in mind, that's different than the authority to actually make decisions on whether to accept or dispose of gifted property. Just moving along then, I know we're running short on time. Let's transition to some of the specific factors that an organization should consider when accepting or deciding whether to accept a particular gift. First and foremost, as Bob mentioned, all 501c3 organizations need to make sure that the acceptance of the gift does not jeopardize their underlying tax-exempt status. Bob gave some particular examples from cases that we've seen. Just another scenario that could come up, perhaps somewhat unlikely, but if an organization is receiving a gift of interests in an LLC, as you may be aware, all the members of the LLC are deemed to engage in the activities of that entity because it's a pass-through entity. So if the LLC engages in activities that are squarely at odds with the organization's tax-exempt status, for instance, if it engages in political activity, something of that sort, then the organization may be forced to decline the gift simply because accepting the gift and having those activities attributed to it would jeopardize its tax-exempt status. That's probably fairly unusual, but certainly a more common scenario is not where the tax-exempt status itself is jeopardized, but issues of UBIT, that if the LLC engages in a regularly carried on trade or business, now the organization, your charity, is a member of that LLC, well, it too is deemed to engage in whatever activity the LLC is doing, and the revenues from that activity may be taxable to the organization as UBIT. And so again, these are issues certainly for the gift committee to be aware of, and whenever necessary, the policy should clarify where the committee is either encouraged or in some cases required to involve outside advisors, legal counsel, accountants, etc. For organizations that are classified as private foundations, there will be additional considerations as well to make sure that the receipt of property and the subsequent handling of that property don't violate any of the Chapter 42 requirements that apply to private foundations. And principally what you want to be on the lookout for there is to avoid any situations of self-dealing or the excess business holding limitations that apply to private foundations as well. And if you have a public charity, then you want to be careful that on any sale of gifted property, you don't find yourself in a situation where there may be an excess benefit transaction under the intermediate sanctions rules. So again, that's just a brief overview of some of the tax issues to keep an eye on in the gift process, and that the Gift Acceptance Committee should be sensitized to know about. So now, in our remaining couple of minutes, let's just run through very quickly some considerations in particular types of gifted properties. Cash, it's always welcome. Nothing wrong with cash. Definitely take it. When it comes to securities, marketable securities are almost as good as cash, and many gift policies will stipulate organizational policies that stock will be sold immediately upon receipt. The organization isn't going to hold the stock indefinitely, and it's worth communicating that to your donors just so that there's no misunderstandings. In contrast to publicly traded stock, closely held securities or other forms of business interests raise more complications. And as we mentioned a moment ago, certainly UBIT is an issue that could come up there. I mentioned LLCs, which may give rise to UBIT depending on the activities of the LLC. If your organization receives a contribution of S Corp stock, that will give rise to UBIT because all S Corp revenue is automatically taxed to charities as UBIT. Just a couple other issues to note. When it comes, and Bob mentioned this earlier, when it comes to gifts of closely held stock or other business interests, there may be limitations on the disposition of those interests, depending on the provisions of stockholders agreement, LLC operating agreement, things like that. And so the gift committee should review those limitations as well to make sure that it doesn't find itself locked in unknowingly. When it comes to gifts of real estate, as we've mentioned, certainly at least a phase 1 environmental survey as well as an appraisal should be considered before accepting the gift. And another point to be aware of now is that the IRS has issued long overdue guidance that gifts to single-member LLCs are themselves deductible, and certainly accepting a gift of real estate or any other property that has the potential for significant liability that's attached to it, charities should strongly consider forming a single-member LLC to receive those contributions.
And just to clarify, a single-member LLC where the charity is a single member, that's an entity that can be disregarded for tax purposes. So for tax purposes, it's as if it doesn't exist, but for liability purposes, it can provide an important liability shield for the charity.
Right, and it's disregarded for tax purposes, and therefore the donor still gets the deduction. But as Jeff said, it provides the added protection of state. It's regarded for state law purposes. Other types of gifts may raise specific deduction issues for donors, and the organization should be aware of those issues simply in order to service their donors well. Examples include contributions of intellectual property. There are specific donation rules that attach to those. Conservation easements, facade easements, those have been in the news quite a bit and have their own sets of considerations. Or, as Dick mentioned, gifts of property that the organization expects to dispose of within 3 years. The Form 8282 would need to be filed. And again, in all of these situations, really the best approach is to have those conversations with the donor at the outset, just so everyone is on the same page. And the gift giving process is both helpful to the organization, fulfilling to the donor. Everyone goes home happy.
Thank you, Yossi. We have, unfortunately, about 5 minutes here for questions. Kelly in the back of the room has a microphone for those of you who want to ask a question here. Let me pose a question probably for Bob from the webinar. We do have several from the webinar. What if satisfying a donor's intent has become impossible, yet the donor is non-responsive to the charity's communication? What's a charity to do? What are some options?
Well, again, as I mentioned, under this new law of MIFA, you have the option of going to the Attorney General and to the local court to get a deviation. It's sort of like, for those of you who remember the old Cypre doctrine, and that's probably the best thing to do. You might also simply say, you might make a risk assessment and say, maybe we're just going to move ahead without it. But there's clearly a process under UPMIFA.
And by the way, anyone here in the room, just raise your hand if you want to ask a question. Another question from the webinar. Are there any rules or prohibitions on the charity paying for the donor's appraisal of non-cash property?
Well, there's no obligation on the donee to do it, but I think, look, it has been done before. They're going to be the recipient of the gift, and they may say, look, we want the appraisal, and I mean, I've seen it done where charities have done that. I mean, it goes into the business judgment of the charity of, do you want to incur the cost of doing the appraisal when accepting the gift? But if the gift is worth it, I think a charity could probably go ahead and do that.
Frankly, in some gift acceptance policies, you also see the reverse, where the organization provides that the donor is going to pick up all of the associated costs for anything that has to be done in the gift process. So you can really go either way, I think.
And the cost of the appraisal, if the donor pays for it, would itself be tax deductible as part of the charitable contribution.
Great point. And we have seen cases, enforcement actions, where the IRS has been very troubled where the donee is steering the donor to particular appraisers. We've seen this a lot in the facade conservation easement area and in some other areas as well where there's been questionable appraisals being done. That's something you want to be really careful about. If you're dealing with donations of certain kind of unique property, be very careful in light of that recent precedent to not unnecessarily steer donors only to particular appraisers. Other questions here in the room?
Yeah, we'll give you, picking up on something Dick said, an example we had in a case where it was exactly the situation Dick warned against, where donor gave real estate to charity. Donor claimed a deduction of X. The donee charity went and sold it, couldn't get that kind of money, took about a quarter of that. What happened is the IRS ended, based on the 8282 and 8283, the IRS ended up auditing the donor for inflating his deduction, turned around and audited the charity, claiming the charity was in cahoots with the donor. It was a very nasty situation.
Yeah, we've handled several of those audits as well. Another question from the webinar: if you want to remove a restriction, is there a minimum amount that you have to go back to the donor to seek permission to remove the restriction, such as $5,000, $500, $50? Essentially, is there any de minimis rule here?
I don't think there is. I mean, there's a judgment call here about $50 versus $5 million, but the rules are the same regardless of the size of the gift.
And I think it varies by state. The UPMIFA versions in different states. I think there are a couple of states, for example, that have put a de minimis amount, which if you want to release a restriction, you simply inform the Attorney General of the state. Hey, Attorney General, we are planning to treat this amount as unrestricted. If you have any objection, let us know within 60 days. And if we don't hear from you within 60 days, we will treat this as unrestricted. But check again your state's version of UPMIFA. And by the way, your state's version of UPMIFA may or may not be the one you think it is. If you are incorporated in Virginia, operate in the district, have a branch office in Maryland, hold a trust from a donor in a bank in Delaware, and the donor lives in Florida, whose version of UPMIFA are you accountable for? And the answer is possibly all of them. But again, go to your attorney, not to your accountant. I don't know the answer to that question. That's a question for these guys, to whose version, because even though it says uniform, it isn't uniform. It varies from state to state.
Right. One final question from the webinar, and this is probably for Dick. Do the rules that you talked about in terms of evaluation of donated property, any different rules or application in the auction context? So if an item is being donated and then it's going to be auctioned off, does the auction price have any effect on any of the issues we talked about, on the 8283 or anything else?
Theoretically, no. I mean, where you have a charity auction, now of course you've got another party in the mix here, but the auction price, while it might be useful information, it does not change the requirement that the donor has to obtain a qualified appraisal for gifts over $5,000, and the charity needs to determine what is the fair value of the gift for recording in its own books. For example, here in Washington, the church I go to has one of our members is the team doctor for the Washington Redskins. As team doctor, he has access to tickets. For those of you who don't know, the Redskins at least claim they are sold out by season subscription for 12 years in the future. In other words, you can't get tickets. So what is, and each year we have a charity auction to benefit our church, and he donates a pair of tickets to one of the games. So what are those tickets worth? Who knows? Not the face value, that's for sure. But I don't know what kind of a deduction he can take for them. I've never asked him about that.
One final question for Bob or Yossi. In the case of a state, so a donor is now deceased, does the estate or some representative of the estate have the ability to provide consent to change the terms of a gift where the donor is already deceased?
Well, I think typically the personal representative of the estate steps in, or the trustee of a trust steps in with that sort of authority. Now, if there are beneficiaries of the estate, typically the personal representative may want to get the consent of the beneficiaries. If the group of beneficiaries is too big or or you can't get to them, then you're back into that whole attorney general court thing where someone will represent the interests of them. So we've all been through that process. Although my experience has always been, if you go to a court and you just say, and nobody's objecting, the court will pretty much approve anything these days. So there you go.
Well, I want to thank Bob and Yossi and Dick for a terrific presentation. I want to thank all of you for participating. The email with the link to the recording and PowerPoint presentation will go out on Monday. You can look for that on Monday. Thank you, and hope to see you back here next month.
Thank you. Please stand by.